Hey everybody, how's it going? Welcome back to Copper Jacket TV. So today we've got a very important development in Duncan v. Bonta. This is an extremely important case that challenges California's ban on magazines that can hold more than 10 rounds. It's currently sitting before the Ninth Circuit Court of Appeals, but the Ninth Circuit Court of Appeals had hinted that they kind of wanted to wait to see what would happen in Rahimi. Well, we have our first post-Rahimi development in Duncan, and it's not good. So let's talk about what's going on here. Now, real quick before we get started, I am proud to be sponsored by Attorneys on Retainer. If you guys remember, I used to be sponsored by another company that was somewhat similar until I found out that it was somebody sitting in a cubicle at an insurance company somewhere determining whether or not I am actually covered. I could not recommend that anymore. I could not suggest it anymore. I had to get away from that. And I am happy that I did, because Attorneys on Retainer, they are actual attorneys, and they are not going to turn you down if something is questionable. If you carry to defend yourself, I implore you to check out Attorneys on Retainer. There's be a link and a discount down in the description box, and you guys need to check them out. When you call Attorneys on Retainer, instead of getting somebody at a cubicle or somebody in a call center somewhere, you actually get an actual attorney, which starts your instant attorney-client privilege. Everything that you say to them is going to be confidential. It is an extremely important thing to have in your wallet. Okay, so let's go ahead and talk about what's going on here. And like I said in the beginning, Duncan is an extremely important case, not just because of what it bans or the fact that it violates your constitutional rights, but it's also holding up another huge case in California that's been around for a while now, which is Miller v. Bonta, and that challenges California's ban on semi-autos. So again, we need a resolution in Duncan. We need a win in Duncan in order to advance Miller. And so again, we have two big cases that are kind of waiting to see what happens here. Now, the Ninth Circuit was waiting on the decision in Rahimi just to see if it would clarify anything in Bruin, and then they could move forward with that. Now, it doesn't seem like Bruin was stopping them at all, so I don't really know what any clarification would do. They'll just find a way around it anyway. But they got the decision from the Supreme Court. Now, I made a video about it. There's a lot of debate, people saying that it's not really anything, it's kind of a nothing burger. And then people like me who are saying, look, there's a lot of language in here that could definitely hurt us. Well, it looks like it has. So let me show you guys something real quick. Okay, so here is the letter I knew was going to be coming. This is from Rob Bonta in the California Department of Justice, just sent up to the Ninth Circuit Court of Appeals today. And this is a citation of supplemental authority, and it is referencing Rahimi. So a lot of the stuff that I said might be a problem language-wise is actually in here. Let me just go ahead and read it to you real quick. Okay, so it says here, appellant, and the appellant is Rob Bonta and the California DOJ, because if you remember, Judge Benitez at the district court level placed an injunction against enforcement of this law, citing that it was unconstitutional, and California appealed. So again, appellant writes to notify the court of the 8-1 decision in United States v. Rahimi. The Supreme Court rejected a Second Amendment challenge to 18 U.S.C. 922G8CI, which prohibits individuals subject to certain domestic violence restraining orders from possessing a firearm. Now, here's where some of the language from the Supreme Court's opinion actually comes back to hurt us, in my opinion, where it says, Rahimi reiterated that the right secured by the Second Amendment is not unlimited, does not sweep indiscriminately, and is not a right to keep and carry any weapon whatsoever, which is something that California loves to say. The court recognized that some courts have misunderstood the methodology of Bruin and Heller, which were not meant to suggest a law trapped in amber. It criticized the Fifth Circuit and the dissenting justice for committing the error of reading Bruin to require a historical twin rather than a historical analog. Imposing a test that demands overly specific analogs has serious problems. This is the same error committed by the district court in this case. So they're basically saying that Judge Benitez was looking for something historically identical, which is not the case. It's just the fact that the state's historical analogs that were used in this case were so off base that they weren't analogous whatsoever. It had nothing to do with being an exact match, but that's what they're using here. Now, it continues on to say, as the Supreme Court explained, the appropriate analysis involves considering whether the challenge regulation is consistent with the principles that underpin our regulatory tradition. Well, I'm going to say banning an entire class of arms or banning something that is necessary for the use of those is definitely not consistent with the principles that underpin our regulatory tradition, that's for sure. It continues on to say, analogical reasoning under Bruin demands a wider lens. Historical regulations reveal a principle, not a mold. In asserting those principles, moreover, it is appropriate to consider post-ratification laws and practices. So basically what they're trying to do now is they're trying to expand on the time frame that they can go to for these historical analogs. Post-ratification history can be important to interpret vague constitutional text and determining exceptions to individual constitutional rights. Now, I don't know about you guys, but I don't think there's anything vague about the Second Amendment at all. It continues on, and this is the end of it right here. It says, applying the appropriate methodology, the court had no trouble concluding that the historical analogs invoked by the government were sufficient to justify the challenged law. Now, it continues again to say, even though those analogs were by no means identical to Section 922G8CI, the Second Amendment permits more than just those regulations identical to the ones that could be found in 1791. Here, the principle emerging from the long tradition of government restrictions and prohibitions on especially dangerous weapons and accessories justifies the challenged restrictions on large capacity, or what they consider to be quote-unquote large capacity magazines. And so just like that, it only took a few days for California to use Rahimi against the Constitution and against the people of that state. They wrote a letter, they had a bunch of quotes in there, they tried to say how that supports their cause, and who do you think is going to bite at that cheese on the hook? Well, it's going to be the Ninth Circuit, right? I mean, the Ninth Circuit is looking for an excuse. I mean, that's kind of what it boils down to right now. Before, under Bruin, the way that it was, without all these different quotes that they can pick apart, it was very simple, right? They had to look at text. If the Second Amendment was implicated, then they had to look at history and tradition of regulation, and they had to find some type of historical analog, and that burden was on the state. The state had to go back and find that. Well, they couldn't find anything that was very similar, right? So obviously it looked like this had to be a slam dunk for us. But now, because of these tiny little phrases and words that they can pick apart, I guarantee you that the Ninth Circuit is going to eat this up, they're going to love it, and they're going to use it in order to uphold California's ban. So that's just my prediction. I could be wrong. I'm hoping that I'm wrong. But if you just take a look at what the California DOJ is putting out there, and you take a look at the makeup of the Ninth Circuit Court of Appeals, again, they're two matching ideologies, right? And so if one can feed off the other, that's exactly what they're going to do. And so even though I don't have a crystal ball and I don't know what's going to happen with Duncan, here soon, because again, they're going to decide it now, I still think that it's not going to work out great for us, and it's going to be because of that language in Rahimi. If not, it's just a pure miracle. But again, we'll be able to appeal it. And you know what? The Supreme Court's going to have to take one of these cases because they're going to keep coming up from state after state after state after state. And I don't think anybody's going to stop until the Supreme Court finally decides to take one of these. They're just going to keep flooding them with them until they finally do. And they need to, because this is getting a little bit ridiculous. Hopefully they'll take one of the Illinois cases that's still sitting before them when they have conference this Wednesday or Thursday, and we'll find out by Friday whether or not they take one of those. But that's not looking great right now either. So anyway, I wanted to let you guys know about that. Again, the Supreme Court's opinion, the Supreme Court's decision in this case is already being used against us by the California DOJ. So if you know anybody that this would be interesting for, make sure you share this video. I always appreciate a thumbs up. If you're not subscribed yet, please consider hitting that subscribe button. It really helps us out a lot here. Thanks again for watching. Have a great day.